sure how
Happening, Your Honor.
All right. So at this point, I went through the file. I see that the mother's objecting, and the court visitor was appointed, and Miss Day, let's see. I was thinking she had done the report, but I have to go back and forth between.
Yes, Your Honor. It was filed back in May of 2023.
Okay. Okay. May 2nd, 23. I see it there. All right. So the report has been, let's see, 5/2/23.
Your Honor, I do want to bring to your attention Mr. Anagnostou as opposing counsel, and I do not see him here.
Oh, okay. All right. So before we do get any further, so we don't have Mr. Anagnostou. Oh, there he is. Just a second. So we have, let's see, Amanda Holder, attorney for, looks like Mr. DePriest, correct?
Correct, and he is here.
Okay. Mr. DePriest is present. We have Mr. Anagnostou. Do we have Melissa Howard present? Okay. Apparently mom is not present. Anyone else present on this matter?
Tina Day, honey, Your Honor, I'm present.
Okay. All right. So at this point, I'm trying to figure out where we're at and what the plan is on this.
Okay. Your Honor, if I may, today I believe the hearing is set for the full guardianship hearing. And so for that matter, I would be fine going a little bit later, since I think it's going to take a little bit longer if we want to get some of the quicker issues out of the way for other cases. But this is the 7th hearing, if I'm not mistaken. This case has been set over 6 times already on an emergency basis. And mother has only shown up for one of the hearings. And she basically objected at the very beginning of this case, but really hasn't pursued her objections. And Ms. Day can correct me if I'm wrong, but when she filed the visitor report back in May, I don't know that Ms. Day has had any contact with mother since then. And I would ask that we proceed on the full hearing, as this has been going on since April.
Mr. Anagnostou?
Yes, Your Honor, that's would be a surprise to me. I didn't believe we were on for anything other than a review. If counsel wants to set this for a trial, that goes on the universal trial assignment docket, and we get a trial date, and parties can show up for the full petition, testify potentially. But my understanding is my client has been working with the petitioner and visiting the child kind of regularly. That was what was happening at the last hearing. Was we were confirming some, I think it was every weekend or some weekend visits, and they were occurring. And my client at the time was in the community house and was having regular contact with the child and with the petitioning party. But I haven't heard from her before this hearing, but I again didn't attempt to contact her because I thought this was just going to be a review.
Your Honor, if that's the case, I am absolutely fine setting this case over and then getting on the universal trial setting docket to get this set out. I do apologize. I don't want to make it feel like I ambushed Mr. Anagnostou. As the statute has been rewritten, I wasn't exactly sure how this was going to go, but I'm fine setting this out and getting on the universal trial setting docket and actually getting a full hearing on this, as it has been 8-9 months.
And that's what Mr. Anagnostou has indicated is what I was looking at. And that's why I was kind of going through where things are at and ultimately looking for, it seems like this needs to get set for trial and be heard on the petition if the parties aren't going to get to any kind of agreements on it. And so that makes the most sense, is to get on the universal trial assignment and get a date set. So, Mr. Anagnostou, would you agree that's?
Yeah, that's what I would expect to occur at this point. I'll get a hold of my client. I mean, I've had pretty good contact with her. I thought we had everything was agreed, but I'll follow up.
Okay.
And just so I'm clear, Your Honor, do we want to extend because at this time, we've extended the emergency guardianship a number of times. We're now set for we have a petition for the full guardianship. I'm not sure under the statute how far we should be setting out for another review hearing prior to getting a trial in this case.
Mr. Anagnostou?
What I have seen in other cases is in the form orders, you can check a box that says the emergency guardianship orders will remain in effect until basically changed or trial on the primary guardianship case. So it's my understanding, Your Honor can enter an order that under what we're doing on a temporary basis on the emergency guardianship that continues until we have trial.
So that makes the most sense, is what's happening now should continue. That's my understanding as well. It's basically the emergency and what's been happening just continues until the time and date of trial. And so if you want to prepare an order to that effect and then get it set on for a trial assignment, then you can get that. You should be able to get that within the next within the next couple of weeks. And so how about we set a review out 3 weeks just to see where things are at and then it moved forward? Who do
Works
we
for me, Your
have
Honor.
present
That's fine
on
with me, Your Honor.
today? So with that.
John Sasaki, counsel for the father.
Current Anagnostou, counsel for the petitioning party, Marion Barrett.
Donald Esau, counsel for the mother, Georgia Woldridge.
And Sherry Farr, the guardian on litem.
So at this point, what I was looking at is, Ms. Farr, do you have any, I didn't see a report filed. Did I miss it or?
No, Your Honor, I haven't filed it yet.
Okay. Can you give me a sense for where you're at with that?
I need to do some follow-up with the parties and then I can probably get something in. We're kind of in the middle of seeing where Flynn is at with the visits with the parents. And I was kind of waiting to see how those are going to go before I'm able to make any kind of recommendations for the near future. He's only had one phone call with the father through the therapist. And so there's another one set up here shortly. And I kind of wanted to get through that first before I could actually make some recommendations.
Okay. Counsel? Anything?
Yes, if I may. I apologize, Mr. Isel.
Go ahead, Mr. Sosowski. That's fine.
I was just first asking if the court had a time to review our objection to the full guardianship.
I have reviewed the pleadings. So at this point, I was looking to review and see the guardian litem report before I actually took any action.
Understood.
Your Honor, I just noticed that that objection was filed I just noticed it this morning when I pulled up Odyssey. I was not aware of that objection, so I haven't read that myself.
I apologize for that, Ms. Farr. I can make sure that that's served to you as well. I thought it had been.
All right, counsel, go ahead.
Yes, Your Honor, Donald Esau for the mother. Mother reports that she hasn't been able to have any visitation through the counselor. And I noticed in the previous order of November 2nd that visitation was actually denied, which I didn't catch. So my client's understanding was that she was supposed to have one telephone call per month with Mickey through the counseling office. Her last visit was November 17th, although Ms. Farr has some updated information to that. But she's telling me that the petitioner is not allowing those visits because because the visits are going with dad. So that doesn't make any sense to me, but maybe Mr. Anagnostou can speak to that. But in any event, she needs to have visitation at least once per month, especially if Ms. Farr is relying on those visits to make a determination as to what should happen here in her report. And on the other matter regarding the objection, I didn't get a copy of the father's objection either. So.
Thank you, Mr. Isel. If I may chime in, according to our staff, that has been mailed out to all the parties, but we can, if you accept service by email, we can make sure that's served to the rest of the parties just to make sure.
I do accept service by email. Yeah.
You're saying on November 2nd, mom was denied? Or,
The order, when I looked at it specifically this morning, it says, right, let's see. I'm just trying to pull it up here. Well, paragraph 14 of the order says nothing, actually. It just says the parent's visitation shall be as follows, and then 3 blank lines. So maybe I misread it somewhere else.
Your Honor, I can give,
oh, go ahead, Ms. Barr. Go
I'm
ahead.
sorry. I can give you a little information about that because I have talked with the counselor. And so Flynn is only receiving 2 counseling sessions per month. He has had several phone calls with mother during those sessions, and they have gone through December. So I'm not sure why she's saying that she hasn't had calls since November. I don't believe that's true. The counselor has now switched over to having phone calls with father. There's only been 1. There's a second one that is set up here this month. And the counselor also said that she's, finding that the focus is because of these phone calls happening within her hour with Flynn, and she only has 2 hours per month, that it's being focused on the parents' phone calls. And she's not a reunification counselor. She is trying to provide him some therapy for the trauma that he's suffered. And so she doesn't want all of these sessions to be focused on the phone calls with the parents. Her and I talked about was maybe her having some phone calls with the parents and setting some boundaries to be able for the parents to make phone calls outside of the therapy session, maybe with Miss Barrett supervising those calls, but we haven't reached that point yet.
When you'll be talking to that counselor again, that you might be able to get something ironed out a little bit more?
After she has the next session with father.
Which is when?
I actually don't have a date in front of me, but it should be within the next 1 to 2 weeks.
Okay.
Because she has therapy with Flynn every other week.
Okay.
I'm sorry. I assume my client would know that date if Your Honor needs to know that. She is here.
January 23rd is the next counseling appointment.
Okay. All right.
So, Your Honor, just if I may, this is a case where Flynn was basically rescued by my client from Chicago, Illinois. And when he got here, he was in very extreme mental and emotional distress. He was having physical problems, bowel movements in his pants and all sorts of stuff, and issues, self-harm and various other things. My client has got him into counseling, and he's in school. He's doing great. He's recovering. He still has some issues that they're working on. And Judge Warning, his ruling was that the visits between the parents and the child would need to start via phone calls with the counselor, so that Flynn was protected during those phone calls and wouldn't be harmed any further. So that's how we got to this point. My client is very concerned about his emotional and mental well-being going forward. He's made a lot of progress, but he still has issues. And we believe that it's just crucial that the counselor continue to be involved in this process, potentially the parties need to get into some reunification counseling outside of his counseling sessions with his counselor to reestablish contact.
Your Honor, if I may add.
Go ahead.
We also wanted to address the issue of visitation. We have the emergency orders here that state that the mother and father may have telephone FaceTime contact with the child if and as recommended by the child's counselor and through the child's counselor. Wanted clarification on that, as Mr. Asau had proposed, if counseling can proceed at a faster or more efficient pace with visitation through Ms. Barrett, subject to parameters set by the counselor, we would agree to such an arrangement.
All right, so anyone else, any further comments?
Your Honor, I
Yeah.
would just say I agree with Mr. Anagnostou that maybe we should be looking at reunification counseling outside of those therapy sessions. Otherwise, the alternative would be to have weekly sessions because the counselors just can't do both within that 2-hour period per month.
So what I'm hearing is the counselor, and I understand why I did read the file and what's been said. But one of the things that is of concern is I saw, what Mr. Anagnostou was talking about in regard to the child when returned, and the state of the child, and that child needs to have that counseling. My concern is that, as stated by the counselor, that the counseling sessions are being taken up with the visitation rather than what the child is actually there for. And so it seems that it would be more appropriate that a party have a separate counselor that maybe the current counselor could recommend, or Ms. Rosen is the only other one that I'm aware of, and I'm not saying that it has to be Ms. Rosen. Here locally is the only one I'm aware of doing that kind of counseling, but that doesn't mean there aren't others. But I think there needs to be two, so that the counselor that's to work with the child works with the child and does not have the time taken up for making these phone calls. The phone calls are important. I don't want to minimize that. And that they are supervised by somebody with the background and experience necessary to address any issues that may come up especially for the child. So I'm wondering, Ms. Farr, if maybe that could be a part of what you have a conversation with the current counselor about, is someone that might be appropriate for that reunification counseling. And if that can occur, then I would want the guardian to go ahead and the emergency guardian go ahead and get the child started in the reunification counseling, so that the child has their own counselor and we aren't mixing the two for the child. That doesn't sound like it's a very good thing for the child. And then the reunification counselor would be focusing more on the visitations, and that way both mom and dad would have their phone calls. Maybe they wouldn't be so limited because of the counselor being concerned about not having the time to actually just work with the child. So it seems like that might be appropriate. Problem is, I don't know who's available for that purpose. And so what I would like to do at this time is, since Ms. Farr is wanting to be present for the phone calls that have been talked about, and then maybe get a report. But meanwhile, Ms. Farr, is it possible for you to make contact with the counselor and get that, get a recommendation from them, and then relate that on to the parties?
I can certainly do that. And then, of course, I would also, there would be the question about the cost and who's covering that additional too. So,
Okay. All right. So let's go ahead and set this out 2 weeks. I think that will give time. I know that doesn't take care of the visits that need to, try to occur. But let's at least get it in the works and try to move this forward.
and so, Your Honor, then if the next therapy session right now is scheduled for the 23rd, there's no way I'd have time to get a report to you by the 25th.
Okay.
I could report orally, but
and I was thinking more about talking to the counselor and getting something set up about the reunification.
correct.
Your report itself, what are you thinking of what amount of time you need for that?
Well, and just to clarify, Your Honor, so the counselor was telling me this morning that she would like to have the one additional call with the father, because she's only had one before she actually recommends those outside reunification phone calls. So I think she wants to set some boundaries and
I see.
make sure it's appropriate first.
Okay. All right. I understand that. All right. So you're thinking maybe February 8th?
Yes, that would be fine.
Okay. So again, I know that's not as fast as mom and dad may like, especially mom, at this point, but, Mr. Anagnostou, if your client was given the boundaries by the counselor, would your client be willing and able to do some supervision of phone calls or not?
She may be willing to do with regards to the father. I'd have to have a conversation with her, but with regards to the mother, she has a very conflicted relationship. Primarily from her point of view that the mother has mental health issues.
All right. Well, at this point, we don't have any alternatives. Counsel, do you have any other suggestions or thoughts? I'm not hearing any.
As to,
Go ahead, I'm sorry.
I apologize, as to the mother's visitation,
Right.
I don't have anything further on that, Mr. Salmon.
Mr. Sal?
Yes, Your Honor. I think it's imperative for the mother to have at least a phone call once per month, maybe twice per month, as they have been doing. But I understand the issue regarding the counseling taking up of the phone calls, and I understand that the mother is not willing, the grandmother petitioner is not willing to supervise those calls. So, and my client is located in the Chicago, Illinois area. So it's difficult to do anything other than FaceTime or Zoom or a phone call. So I'm not sure what to recommend other than to keep doing what we're doing until we get some reconciliation counseling going.
Okay. All right, Mr. Anagnostou, you had something?
It's left my mind at this point.
Okay, no
Yeah.
problem. So I think we're just going to essentially make it status quo at this point. I know that's not necessarily the best plan, but I don't think we have any alternatives at this time. Ms. Barr will make contact with the counselor and try to see about reunification counseling as an option, and that the visitations could take place through that versus the counselor working with the child. And then we'll go ahead and set this to February 8th at 10:30 a.m. for review and the Guardian Litem's report. And hopefully we'll have some recommendations about the reunification counseling at that time. Okay.
Your Honor, I have one more item, please.
Okay, go ahead.
So I respectfully ask or request permission to bill and request additional funds. We were budgeted at $1,500, and we've gone substantially over that. And so I respectfully ask for permission to submit billing and for additional funds going forward.
Okay, so I would ask that you reduce that to a motion, submit it to the court, and we can see what you've been doing and can make that determination and make your request for additional hours and the basis for that, and then the court can take a look at it.
Understood. Thank you.
Okay. All right. Thank you very much. I think that takes care of today's matter.
And Your Honor, we will need a order extending so the letters can be extended. Yeah,
that's true. Mr. Anagnostou, can you prepare that, please?
I can, Your Honor.
All right. Thank you.
Thank you.
Guardianship
Thank you,
of
Your Honor.
Emma Ryan. Thank you.
Thank you.
Good morning, Your Honor.
Good morning. All right. Who do we have present here today?
English.
Matthew English.
Josh Goodday, Your Honor, present on behalf of Lauren Ryan.
Roy Flay, present, Your Honor, for the petitioners.
Okay. And I am not seeing either parent. So with that, I did receive the declaration petitioner in support of sanctions for respondent. Again, going back, and there had been a show cause for contempt. I had set it over essentially to see where things were when, or I signed the order with the additional language. in some terms, but understanding that additional requests could be made based on what occurred. I did read the declaration of what did or did not occur as it may be. So Mr. Flay, anything else you wanted to add to that?
Your Honor, we also wanted to request, because last hearing actually was a review hearing for the minor guardianship at large, not just the emergency guardianship. So we still need to have an actual temporary order issued in the general minor guardianship. This is important that we have, a temporary custody order that has a deadline beyond just a week. We've been doing all these hearings where there's, short-term emergency orders granted. I don't think any of us anticipated emergency minor guardianship going on, about 4 months now. So we would request that, a temporary order be put in place reflecting the Englishes as the minor guardians in the general minor guardianship. I think in order for us to move anything forward as well in California, the courts down there need a certified copy of something showing that they are the minor guardians, in fact, for a set period of time that's not just indefinite or a week. So I think it's very important, because originally last week's hearing was scheduled just to be a review hearing, turned into a contempt motion based on recent actions of the respondent. So we just want to make sure that's revisited.
Okay. All right. Did you happen to submit any proposed order reflecting any of that, Mr. Flay?
Your Honor, we did when we first filed the initial case. I understand that, probably that's not in the bench copies, obviously. So we're more than happy to submit one via email today or whatever method's preferred. But we just prepared essentially for what was ordered from last hearing, and at no one's fault. I think it just wasn't discussed last time. So whatever method you prefer, Your Honor, we can prepare it.
When you filed the proposed, when did you file that? Do you know?
Everything for the initial minor guardianship would have been back in late September. So I don't know if you even would have received a bench copy. This was also multiple different judges ago. And again, it's a proposed order, so the bench copies wouldn't have necessarily been filed with the court.
Right, and I understand that. I'm just trying to pull up what you're proposing as an order so I can make sure there's no issue with it, but I'm not. Let's see. This petition was filed in October of 23. Okay. Well, I'll come back to that. Mr. Goodday?
I have a few things, Your Honor. So my client texted me this morning. She's asking for a new attorney in the case. I feel there are she doesn't have any confidence or trust in me. I feel there's a breakdown in our communication. Could be irreconcilable differences. She also wanted the court to report a GAL and do a full investigation on the case before ordering Emma to be turned over to the petitioners.
Anything else?
No, Your Honor.
Mr. Flay, anything?
Well, Your Honor, we would ask that Mr. Goodday not be excused from the case. I don't know what correspondence that has been reflected between them, but at this point, any correspondence dealing directly with Ms. Ryan has proven to only be very difficult, if any at all. So, we're very appreciative Mr. Goodday's on the case. It makes things a lot easier to work with this juncture, but I don't see a reason for him to be dismissed unless we see something filed showing that correspondence. And then regarding the guardian ad litem, Your Honor, I believe we asked for guardian ad litem initially in our petition anyway, so we're in no opposition to guardian ad litem being appointed. However, I think Ms. Ryan's motive for that is to show that the Englishes are not fit, or I'm not really sure what her strategy is there, but a guardian ad litem can be appointed and my clients still be guardians at the same time. They can do a report with Emma in the English's care. Moreover, we're still dealing with a situation where Emma is not in their care. So the person asking for a guardian ad litem has been adamantly disregarding the court orders since October. I don't think it's fair that the court should grant their wishes for the purpose of questioning my client's ability to be guardians when they haven't even been able to do that yet. So, we're standing by our position in our contempt requests. We think jail time's appropriate. All the sanctions that listed are appropriate, and all the financial compensation that we've requested in the money judgment is also appropriate. Thank you, Your Honor.
So in regard to the mother's request regarding Mr. Godet, I'm not hearing one, she's not even present. She hasn't been present. She hasn't responded. We're in the middle of contempt actions, and it would not be appropriate at this point to leave her without an attorney when we're looking at the idea of a warrant for her arrest and jail time. So at this point, I will not be removing Mr. Godet as the attorney. As far as the guardian ad litem, at some point, we will get to that. Right now, the focus is on her complying with a court order, and that still hasn't occurred. So, Mr. Godet, I don't know if you have any response in regard to that matter.
I did some research, Your Honor, and I did accept service, but Miss Ryan was not personally served. So my understanding is that jail time could not be ordered due to that. That's just based on my research and speaking with other attorneys. So I'll defer to the court if that's true or not. But
and Your Honor, can we
otherwise we're
respond
still
to
in the
that?
same situation.
Mr. Flay?
We've asked numerous times, where is Miss Ryan? Where's Emma Ryan? We don't get an answer. We have no idea where Miss Ryan is. The only course of action we have is to serve Mr. Godet. Again, it seems Miss Ryan wants to play by her own rules and then fall back on technical procedural rules when the issue is even possible. So I think it's more than reasonable. We could have attempted personal service if we knew where she was. We had to stake her out initially in this case to even serve her at a courthouse when she was dodging service at the women's shelter. So I think it's more than clear that, if Miss Ryan really wanted to be served, or if that was the issue at hand, she would have still gone above and beyond to avoid service. So I would object to Mr. Godet's request for it to be denied.
I'm concerned, and I understand where Mr. Flay is at, and I also understand what Mr. Godet has indicated. My concern is that she's intentionally hiding from service. So at this point, the fact that she is in contact with her attorney and that she at least knows enough of what she's doing to make the request that she's making, then the court sees that she has knowledge of what's going on and is intentionally evading the service of the guardians or the emergency guardians. So my question is, Mr. Flay, at this time, with all that, do you have any legal basis when personal service has not been made on the mother to issue a warrant? And I'm not saying there isn't, but it's not an issue I've dealt with for a while.
And Your Honor, I would have to research and do a memorandum to the court on that. But in my experience, under Judge Warning and others, this has been an issue that didn't seem to bar from that being a warrant being issued. So again, I'm concerned. I think we've exhausted all remedies in attempting to find her, and her refusal to show herself would bypass, the ordinary procedure there. I would have to again write a memorandum to the court, which again is buying Miss Ryan more time, which is very concerning because we do not know the whereabouts of Emma. So I think it's an exigent circumstance that we need to, do something. I think also it's important that Miss Ryan be ordered to appear in court, because if we are to issue a warrant, we need to, make sure that it can be acted on. But I guess for safety purposes, mostly it just seems strategic to have a warrant out in case, you know, Lauren is in a situation where she runs into police, and then we can find Emma that way. Again, but I would have to do research on that, and that would buy us more time and cost my clients more legal fees to get that done. So, because we haven't, obviously, most of us have not dealt with a circumstance like this, so it's highly unique and needs to be researched thoroughly before I can give an answer, legally speaking.
Yeah, I just want to make sure that we're on good ground. I'm not necessarily opposed to it. I just want to make sure that I'm in good standing to do so. So I'm going to take a few minutes and I want to go look up something, and I will be back. We can go off the record. 8. All right. I've had an opportunity to process and think a little bit more about this. And first off, I am aware that the mother had full knowledge and directly told that she was to turn the child over, that she has intentionally failed to turn the child over, that she has hidden herself and hidden the child from turning the child over as ordered by this court. This matter was on last week. At that time, a request was made for a warrant, and I set the matter over 1 week for the opportunity for the child to again be turned over before issuing any warrant. It is clear from what I'm hearing that the mother has been in contact with her attorney. It was the attorney that was served with the show cause hearing, that the mother clearly knows about the show cause hearing and the request for contempt, including the warrant for arrest. That for all purposes, she has full knowledge of the request to find her in contempt and the sanctions that are being requested, that she has, and again, intentionally avoided the order of the court that has been made with, again, full knowledge of what she is supposed to do. For that reason, I will find that she is in contempt, that the mother has intentionally, again, avoided and failed to follow the order of the court, and that there appears to be absolutely no way to get her to appear before this court without a warrant for her arrest. That she can purge that by appearing next Thursday at 10:30 a.m. at the Cowlitz County Superior Court, courtroom 3, second floor, and appear with the child to answer. If she fails to do so, the warrant will remain out. That said, anything further regard to the penalties, fees, and costs and expenses?
Your Honor, just we just asked for what we requested. Again, we filed all the travel expenses that my clients incurred this past week. I think our order said 1,000, Your Honor. I believe last hearing you said it would be $250 of the 1,000 from sanctions. And then today, I think correctly, we should be asking for $750.
Right.
And then $5,000 in attorney's fees.
Mr. Gooday? Why don't? By chance? Why don't?
Nothing on that, Your Honor. I just wanted to clarify about the warrant. You said she can purge it by appearing next Thursday.
Right. And so to clarify further, the warrant will not go out until, so I'm going to set it on for Thursday for her to appear with the child on that day, and that she will turn the child over to the English or the petitioners. And so the warrant actually won't issue until after next Thursday's docket.
So that's next Thursday in person, courtroom 3.
Right, 10:30 a.m.
All right, thank you.
So I'm modifying the proposed order and putting for the civil penalty 750 because last week I did order 250 based on the intentional actions of the mother and the time that it's been taken or been taking. I am going to order $5,000 in attorney fees and costs, that an additional $2,644.06 for travel expenses based on the documentation that was shown for the petitioners to travel again to California to try to pick up the child. I adopt the otherwise I adopt the proposed contempt hearing order. And the court does find that the mother was able, but not willing to follow the order of this court. And then under paragraph 10, jail time, I put reserved until January 18, 24 to give the mother the opportunity to appear in person with the child at 10:30 a.m. Courtroom 3. If fails to do so, this paragraph applies.
Your Honor, so you're indicating that you will impose the jail time on top of the warrant if she doesn't appear Thursday?
If she doesn't appear, the warrant will issue and she'll be jailed until she turns the child over.
Understood.
No, I think I probably should have written this differently. I have another copy of this order. I'm gonna rewrite this. Yeah. Remover, the staple remover. I'll put this together. All right, so I'm going to rewrite this a little bit. So on paragraph 1, I changed civil penalty to 750. The other remains. Paragraph 3 is adopted. There's supposed to be a paragraph 4 because I'm not saying it.
Your Honor, I think that would have been,
Other findings?
yes, I think after the emergency guardianship order was not obeyed, there's the ability to follow orders bad faith. I think it should be there. Your Honor, I think I realized the issue. The section, the number I think just got moved because we didn't use section 3, which is supposed to be for support payment issues. There were no support payment issues, so that was omitted. But that was just accidentally taken out. But
I made other findings, paragraph 4, and I'm putting the mother is represented by an attorney and it's clear she has full knowledge of the show cause hearing on contempt and has intentionally avoided appearance before the court and is hiding, as well as hiding the child. Okay, so what I've added under jail time says once a minor child, Emma Ryan, is immediately surrendered to the petitioner's emergency guardians by January 18, 24 at 10:30 a.m. Courtroom 3 of the Hall of Justice, 312 Southwest 1st Avenue, Kelso, Washington, 98626. If fails to do so, a warrant for her arrest shall be issued. The court will review compliance with these conditions at the review hearing set in section 12 guardianship docket. Does that work, counsel?
that should be fine, Your Honor. I'm assuming the rest of the parties still may appear via Zoom.
Right.
Besides Englishes, they'll need to be there for
They'll need
transfer.
to be there for the child, correct?
And then I think that's everything for the contempt order. I was just hoping we could revisit the minor guardianship temporary order.
Okay, just a second. So in regard to this, Mr. Gooday,
In regard to your order, Your Honor?
yeah, are you okay to put approved as to form via Zoom?
Yes, Your Honor.
Okay. All right, so the other counsel, go ahead on that.
Thank you, Your Honor. Just basically reiterating our previous points on the temporary order for minor guardian or the general minor guardianship. We don't have a proposed order sent with those bench copies. However, we're happy to get one over as soon as possible. But the concern is that the attorney for the Englishes in California wishes to file a petition for a habeas corpus to find the child, and they need more than just the weekly orders that we've had listing how long the guardianship is for. So we'd be asking the court to order on a temporary basis for the general minor guardianship that Brooke and Matthew English are the guardians under that order. Again, we need to submit that so we can email that if that's allowed, to get it into you as fast as possible. But at this point, we've been well beyond the emergency minor guardianship timeline given the circumstances, but we haven't had any review hearings on the general minor guardianship yet. So we're hoping to get an order to reflect that so they can move forward with having something to be able to find Emma possibly in the state of California.
Mr. Gooday?
Your Honor, I would think on a general minor guardianship, my client would have the right to a hearing versus just the temporary emergency.
Well, to clarify, Your Honor, the last two hearings technically were review hearings for the general minor guardianship that were set a month prior. The fourth hearing, in fact, was set by, I believe, Judge Warning originally to be a review of the minor guardianship. Unfortunately, the contempt became a much more pressing matter, but the court never actually reviewed it. So we're hoping to get a review of that today, but that was the court's intention when that review hearing was set. So I think the opposing party has had sufficient notice and knew that this hearing was coming. Whether she understands that or cares about that, that's besides the point. So.
Mr. Gooday?
I would just request, if we're going to do a general guardianship, that there'd be the full hearing with the guardian ad litem.
And Your Honor, if the court doesn't want to move forward today, we'd at least ask for an official order extending the emergency minor guardianship, something to show other courts in other states that there is a set time that Brooke and Matthew English are the minor guardians for MRI. But currently, we don't. Things are moving so quickly with this case. We haven't really had, or at least sparingly had, orders to say so. So we'd be asking at least for something extending the emergency minor guardianship at the very least, and then a review on the general minor guardianship as the court had originally set for these hearings.
Mr. Gooday?
That sounds reasonable.
So the court would agree with that. I have a hard time doing the other. I agree that a guardian investigation needs to occur, and before we move into that, understand what you're needing and why you're needing it. I have no problem with the other order that you proposed on the emergency guardianship. So if you can get me that order, I can sign off on that. So if you could submit that to Mr. Gooday for review and then get that to me, I'll go ahead and accept. Typically, I won't accept email orders. I want them in hard copy, but again, recognizing there are several things happening here, and the court is wanting to get this moving forward. So I will go ahead if you get that emailed to me.
Thank you, Your Honor. And just to clarify, are we setting a period of time for that to be lasting for 30 days?
30 days would be the appropriate time.
Okay.
Your Honor, if I may,
Go ahead.
this is Sherry Carr, guardian ad litem, and I would just like you to be aware that I have a conflict in this matter. I know that the court is short on guardian ad litem, people to serve as guardian ad litems. There was a previous investigation that I was appointed on involving one of the other children, and part of that agreement was that my report was sealed and I was prohibited from testifying any further. And so because of that, I don't believe it would be appropriate for me to serve in this case.
Okay, thank you for that information. I appreciate it. So counsel, if you would just keep that in mind when we get to the appointment of a guardian ad litem. Okay.
And to clarify, we're just reserving on the issue of guardian ad litem for today?
Correct.
Okay.
Yeah, and it has a lot to do with English, the temporary emergency guardians haven't had the child, and they're not going to get very far with the guardian ad litem at this point. I don't think if it continues like that, then we probably don't have any choice but to move forward. But at least that's my concern at this time. I think the guardian ad litem would want more information, and we just don't have it yet. Okay.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, counsel.
And so, Mr. Flagg, bring the guardian ad litem issue up again. The other thing that would be an issue is we're going to have to find somebody, because we're limited on who we even have available. And if the one that we usually have can't do it, then we're going to have to find somebody else.
Okay. Your Honor, I imagine, I'm sorry if I'm speaking on a lot of hypothetical timelines here, but I imagine, after next week, the exchange would happen. I'd imagine we would be citing on some sort of review for the actual general minor guardianship. Should we be motioning for a guardian litem, or it was requested to be?
No, that's fine. You can just bring it up like you did.
Okay, thank you, Your Honor.
Yeah, and I think Mr. Gaudet was wanting it as well. His client was wanting it too.
Okay.
Okay. All right, so I'll sign off on the contempt order. Get me the other order. We'll set it over 1 week for the mother to appear with the child, or a warrant will be issued and she'll be facing jail time. And then in regard to the guardian ad litem, let's just bring that up in 1 week. Let me give staff an opportunity to see who they can get, because just rethinking it here, that we probably need to get that moving forward no matter what. And so let's go ahead and put the guardian ad litem part on too. Okay. All right. That concludes this matter.
Thank you, Your Honor.
Thank you, everybody.